Hey everybody, welcome to another episode of Foreclosure Help 777, where we talk about everything foreclosure related. And guys, if you have any questions or comments, or you just want to send me an email telling me about your foreclosure, my email address is foreclosurehelp777@gmail.com. And as you know, I am not an attorney and I don't give legal advice. I'm just a homeowner just like you who fought foreclosure, and I'm here to help you. So let's talk about today's subject. So today's subject is called surviving dismissal, when your case gets thrown out. And the Bible verse of the day is Proverbs 24:16 that says, "For though the righteousness fall 7 times, they rise again." As homeowners, we often view dismissal at the end of the road, but Proverbs 24:16 reminds us that setbacks are not the same as defeat. In the legal process, a case may be dismissed for procedural reasons without the court ever deciding whether the underlying claims have merit. A dismissal can become an opportunity to learn, strengthen a case, correct deficiencies, or pursue another lawful path. Just as the righteous rise again after falling, homeowners should not lose hope just simply because they encounter a setback in court. Instead, they should carefully study the dismissal order, understand the court's reasoning, and prayerfully determine their next steps with wisdom, perseverance, and faith. So dismiss doesn't always mean defeated. Procedural dismissals versus dismissals on the merits. Why courts dismiss cases, why it's important to read the dismissal order carefully. Many homeowners believe that if the judge dismisses their complaint, their fight is over. In reality, a dismissal is simply the court's ruling on that particular complaint or that particular case. Whether that homeowner can continue depends on why the case was dismissed and what the dismissal order actually says. So, procedural dismissals versus dismissals on the merits. A procedural dismissal means that the court did not decide whether the homeowner was right or wrong. Instead, that the court found a problem with the way the case was brought. Examples include lack of subject matter jurisdiction, lack of standing to sue, failure to properly serve defendants, failure to state a legally sufficient claim, failure to prosecute, missing deadlines, and filing in the wrong court. The judge is essentially saying, I cannot decide this case because there is a legal or procedural problem. That is very different from saying you lose because your claims have no merit. Many procedural dismissals are without prejudice, meaning the plaintiff may have another opportunity to correct the problem if the law allows. Now, dismissal on the merits is different. Here the court has actually considered the legal sufficiency or substance of the claims and determined that the plaintiff is not entitled to relief. Examples might include summary judgment against the plaintiff, claims barred by res judicata, claims barred by collateral estoppel, failure to present evidence supporting essential elements after the final opportunity to do so, and there's always the final judgment after trial. These dismissals are much more difficult to overcome because the court has reached a substantive decision rather than simply identifying a procedural defect. Why courts dismiss a case, or why do they do it? Judges are not required to fix a complaint for the plaintiff. Common reasons include the complaint contains conclusions instead of facts. Example, the bank committed fraud. That's a legal conclusion. A stronger pleading explains who committed the fraud, what was said or done, when it occurred, where it occurred, why it was false, and how the homeowner was harmed. Courts generally require factual allegations and not just accusations. The claims are legally barred. For example, statute of limitations, res judicata, lack of standing. The statute of limitations, for example. It's a law that sets the deadline for filing a lawsuit. If the deadline expires, the court may dismiss the claim regardless of its merits. Example, A homeowner discovers a RESPA violation but waits beyond the applicable statute of limitations before filing suit. The court may dismiss the claim because it was filed too late. Res judicata, or claim preclusion. This doctrine prevents parties from relitigating claims that have already been finally decided or could have been raised in an earlier lawsuit between the same parties. Example, a homeowner sues over a particular foreclosure issue and loses after a final judgment and later files another lawsuit based on the same underlying transaction seeking the same relief. The later case may be dismissed under res judicata. Lack of standing. Standing asks whether the plaintiff has sufficient legal interest in the dispute to bring the claim. To establish standing, a plaintiff generally must show an actual injury, that the injury was caused by the defendant's conduct, and that the court can provide a remedy. Foreclosure example. Suppose a homeowner files a claim based solely on alleged defects in an assignment between lenders, but cannot show how those alleged defects cause the homeowner a legally recognized injury. Depending on the claims and the applicable law, the court may conclude that the homeowner lacks standing to pursue those particular allegations. Even if someone believes that they have been wronged, these legal doctrines can prevent the court from hearing the claim. Required procedures were not followed. Here are some examples. Improper service. Failure to amend within the time allowed. Failure to respond to motions. Failure to comply with court orders. Courts expect litigants, including those representing themselves, to follow procedural rules. Okay, now why reading the dismissal order is so important. This is where many homeowners make a mistake. They see case dismissed and stop reading. The most important part usually comes after those words. Look a bit closer. Was the dismissal with prejudice or without prejudice? Did the judge grant leave to amend? Which claims were dismissed? Were any claims allowed to continue? What reasons did the judge give? What deadlines were established? Did the judge explain how the complaint could be corrected? Those details often determine what options remain. Here's a practical example. Suppose a homeowner files a federal complaint alleging fraud but provides only broad accusations without supporting facts. The judge dismisses the complaint without prejudice and grants 30 days to amend. At that point, the homeowner has not necessarily lost the dispute. They may have an opportunity to file an amended complaint that addresses the deficiencies identified by the court. By contrast, if the court dismisses the claims with prejudice after determining that they cannot proceed as a matter of law, the plaintiff's options are generally much more limited, such as pursuing an appeal if there is a legal basis to do so. The court lacks jurisdiction. Federal courts in particular can hear only certain types of cases. Sometimes homeowners file in federal court when the claims belong in state court, and of course vice versa is true. Common reasons pro se cases are dismissed: failure to state a claim, lack of jurisdiction, improper service, missing deadlines, pleading conclusions instead of facts, suing parties who are immune and or not proper defendants. What can you do next? Well, you can file an amended complaint if allowed. You can appeal if it's appropriate. You can refile if the dismissal was without prejudice. You can continue defending the foreclosure in state court if the federal case is over. Use discovery or public records to strengthen future filings. Dismissal works both ways. Dismissal is not a remedy available only to the banks, only to homeowners. Courts dismiss cases by either side when the law requires it. Let's compare the two. Here's a difference between a homeowner's complaint versus a foreclosure complaint by the bank. Failure to state a claim, failure to state a cause of action. Lack of standing, plaintiff lacks standing. Lack of jurisdiction on both sides, it's the same. Failure to prosecute, it's the same. Failure to comply with court orders, it's the same. So the same rules apply to everyone. For example, in a judicial foreclosure, a lender's complaint can be dismissed if the lender cannot adequately plead or establish required elements such as standing to enforce the note and mortgage, compliance with conditions precedent when required, required statutory notices, a legal sufficient cause of action, compliance with applicable procedural rules, The precise requirements depend on the state foreclosure law and procedural rules, and always read the local court rules. We spent a lot of time talking about homeowners having their cases dismissed, but remember, foreclosure plaintiffs file complaints too, and those complaints are also subject to the rules. What is dismissal for lack of prosecution? A dismissal for lack of prosecution occurs when the party who filed the lawsuit fails to actively move the case forward. Courts expect cases to progress. If nothing happens for an extended period, or if the plaintiff repeatedly ignores deadlines or court orders, the court may dismiss the case. Think of it this way. The court's saying, you filed the case, but you're not going to pursue it, so we're going to remove it from our docket. Common reasons include failing to serve the defendant, failing to respond to court orders, missing important deadlines, failing to appear at hearings, never filing required documents, letting the case sit inactive for months or even years. Homeowner example. A homeowner files a federal lawsuit. The court orders the homeowner to file an amended complaint within 30 days. Nothing is filed. The court issues another order. Still nothing happens. Eventually, the judge dismisses the case for failure to prosecute. Judicial foreclosure example. This also applies to foreclosure plaintiffs. A bank files a foreclosure complaint, then no activity occurs. Discovery is never completed, hearings are missed, deadlines pass, the bank ignores court orders. Eventually, the judge may dismiss the foreclosure action for lack of prosecution. This happens more often than many homeowners realize. Although the specific standards and time periods vary by state, I would say New York probably has the most of these. I've seen them in the NYSEF docket, where they get thrown out because nothing happens. Is it with or without prejudice? That depends. Sometimes the dismissal is without prejudice, allowing the plaintiff to refile if the law permits. Other times it's with prejudice, particularly if there has been repeated non-compliance or serious delay. Again, the dismissal order will tell you. Failure to comply with court orders. Courts expect all parties to obey court orders and participate in required proceedings. Examples include failing to file an amended complaint after being ordered to do so, failing to respond to discovery, failing to attend hearings, failing to participate in court-ordered mediation, ignoring scheduling orders or pre-trial deadlines. If a court orders mediation, it is not optional. Failing to appear or participate in good faith can result in sanctions, depending on the circumstances and governing rules. Those sanctions may include dismissal of claims, default judgment, monetary sanctions, or other appropriate relief. Judicial foreclosure example. Suppose a homeowner is ordered to attend foreclosure mediation. Instead, they don't appear, they refuse to participate, or they repeatedly ignore the court's mediation order. The court may impose sanctions. In some jurisdictions, that can include dismissal of the homeowner's claims or defenses, although the specific consequences depend on the applicable rules and the circumstances. Failing to comply with court-ordered mediation may result in sanctions, including dismissal or other consequences depending on the court's rules and the circumstances. Failure to properly serve defendants. Filing a lawsuit is only the first step. After filing, the plaintiff must notify each defendant that lawsuit has been filed. This is called service of process. The purpose of service is to ensure that every defendant receives notice of the lawsuit and has an opportunity to respond. Why is service important? Our legal system is built on the principle of due process. Before a court can exercise authority over a defendant, the defendant generally must receive proper notice of the lawsuit in the manner required by applicable rules. Without proper service, the court may lack personal jurisdiction over that defendant. Common mistakes, examples include serving the wrong person, serving the wrong business entity, mailing the complaint when personal service is required, missing the deadline for service, failing to file proof of service with the court, assuming that emailing the complaint is sufficient when the rules do not permit it. So what can happen? If service is defective, the court may allow additional time to complete proper service, or quash the defective service and require it to be done correctly. dismiss the claims against the improperly served defendant. In some circumstances, dismiss the entire case if service is never completed within the time allowed. Here's a foreclosure example. Suppose a homeowner files a federal lawsuit against the servicer, the trustee, MERS, and the law firm. If one of those defendants is never properly served according to the applicable rules, the court may dismiss the claims against that defendant, even if the complaint itself is otherwise legally sufficient. Why an opposition to a motion to dismiss matters. Receiving a motion to dismiss does not mean your case is over. It is your opportunity to explain to the court why your complaint satisfies the law and why the case should move forward. Failing to file an opposition, or one that does not address the legal arguments, may increase the likelihood that the court grants the motion. What is an opposition? An opposition is your written response to the defendant's motion to dismiss. It gives you the opportunity to respond to the defendant's legal arguments, explain why your complaint states a valid claim, point out to the court the factual allegations in your complaint, cite statutes and case law that support your position, and why a memorandum of law is important. A memorandum of law is where you explain why the law supports your position. And remember, the defendant filed legal arguments. Your response should also include legal arguments as well. A strong memorandum of law typically includes applicable statutes, relevant case law, rules of civil procedure, legal analysis applying the law to the facts alleged in the complaint. Simply repeating the facts in the complaint is often not enough. Don't just say the judge was wrong. Instead of writing the defense are lying, explain, accepting the well-pleaded allegations as true. The complaint plausibly states a claim for relief under Rule 8 and therefore survives dismissal under Rule 12b-6. That's the kind of legal argument courts expect to see. Address every argument. If the defendant raises 5 grounds for dismissal, try to respond to each one. For example, standing, jurisdiction, failure to state a claim, statute of limitations, res judicata. If you ignore one independent basis for dismissal, the court may grant the motion on that ground even if you effectively rebut the others. Remember the standard. At the motion to dismiss stage, the court generally assumes the well-pleaded factual allegations of the complaint are true. The question is whether those allegations, if true, state a legally plausible claim for relief. That is why the memorandum of law is so important. It explains why the facts you've alleged satisfy the legal requirements of your claims. A dismissal with prejudice may not end every legal avenue. A dismissal with prejudice generally means that the particular claim that was dismissed cannot be refiled in that court. However, that does not automatically mean that every possible legal claim has been lost. In some situations, different causes of action may still exist. Different legal rights may arise later. Another court may have jurisdiction over different claims. A homeowner may still defend against a foreclosure action in state court, even if a separate federal lawsuit has been dismissed. The important question is not simply where to file next, it's whether different legally viable claims still exist. Example, a homeowner files a federal lawsuit alleging violations of certain federal statutes. The federal court dismisses those claims with prejudice. That dismissal generally prevents those claims from being brought again. However, the homeowner also has independent state law claims that were not decided, or there is an ongoing state foreclosure action where the defenses may still be asserted under state law. Those matters may still proceed depending on the applicable law and procedural posture. A dismissal with prejudice usually ends that particular claim, but it does not automatically end every possible legal right or every other lawsuit. Always determine exactly what the court dismissed before concluding that all legal options are gone. Okay guys, I hope this was informative to a lot of y'all out there. Again, if you have questions or comments, you can leave them below. And as always, everyone have a blessed day.